Good morning again. Once again, I'm Coalter Baker, Southwest Regional Director, and I'm going to switch hats right now and go from trying to moderate and host to being a presenter. I am currently serving, in addition to the Regional Director, as the Chair of the Uniform Accountancy Act, and would like to, let's see if I can get this. And I'm going to be assisted with his keen legal insight today by Noel Allen. So with that, what I'd like to do is, I'm not going to read these slides. I thought it would be helpful for the new attendees especially, and some of the other folks, because I know when I first started out with NASBA, I heard about the UAA, but I didn't really know much about it. So what I want to do is just indicate a couple of key points here for you. You know, it was established by both the AICPA and NASBA back in the mid-'80s. And much like your state law and your rules that underlie that, it is a model for all of our states. So you can get a copy of the Uniform Accountancy Act. There's also a set of model rules and also some appendices that include the statement on standards for CPE programs, which you'll be hearing about later in this program. So the goal is uniformity, but do all states adopt? No. We understand that, but it's a goal for NASBA and the AICPA in coming together and putting forth proposed legislation. The work actually comes from a couple of places. It comes from NASBA and AICPA leadership who meet at their summits and other times. It also comes from our committees. So for example, we've got committees on CPE, and in the future, probably education, and I know in the future, the CPA examination. The way the committee is structured is currently both the AICPA and NASBA have 10 members on the committee. We're co-chairs. My co-chair that I share is the highly respected Gary McIntosh, who's been serving the AICPA for a number of years. Terrific guy to work with, and we happen to live in the same town, so we can settle all of our differences, if there are any, at lunch. Each volunteer adds a new perspective to what we do. And as we take on projects, and I'll list the members, the one thing that's great about this committee, at least for the NASBA side, it's a very veteran committee. We have former board chair Barton Baldwin. We have Ken Odom, who's a former director here at NASBA, among others, Andy DeBoff as well. In fact, we only had one new member this last year, and that's Dan Sweetwood, who's the executive director from Nebraska. And what's great about that is it now gives us two executive directors, both John Patterson from Ohio and Dan serve in that capacity. The AICPA also has some stalwarts as well. I mentioned Gary, and also I've worked with Nancy Giron and Debbie Lambert, among others, and they're great to work with. And I will say this, is even though we may have a little bit different perspective coming into the committee, everyone is out primarily to protect the public interest. So that's always heartening for me. In 2014, 2015, once the committees were formed in late fall, this is the way it laid out for us. Our activities were basically every couple of years, the staffs of both the AICPA and NASBA go through both the Act and the model rules, and they look for items that are either inconsistent or outdated. We just had the CPE standards release, which you have until October 1st to respond to the exposure, and we expect to receive the model rules update from that committee as well. Mentioned Ted Loden earlier in the International Qualifications Appraisal Board in looking at the potential for allowing foreign credential holders to gain CPA licensure when the host country they come from may not allow for the same for us. SARS-21 recently passed, may or may not have some impact, but we're certainly looking into it. And finally, the bulk of the efforts so far to date have been related to the inactive retired. As I mentioned, staff goes through initially and they identify rules and language that need to be changed. I believe, I may be wrong on stenographers, but there was a pretty old word in the most recent edition. Two staffs have cleaned up those items and are now going to go to leadership of both NASBA and AICPA to identify if there are substantive issues that need to be discussed. And that's probably true because as we pass some I guess, monumental laws as it relates to a test and firm mobility and other items, there may be some inconsistencies. We want to make sure we don't have any of those. As I mentioned earlier, the CPA Standards Committee actually have issued the CPE standards, and as I said, the model rules will be coming out shortly. I have had the opportunity, and this was one of those situations where it really worked out well. It was very well coordinated. So I was first named UAA chair back in October, November. Immediately, I received notification from Maria Caldwell and Jessica Luttrell, who are the staff liaisons of that committee, asking me to come to the meetings, become involved. And first myself, then Ken Odom, who chairs that task force, were allowed to sit in. And I'll tell you this, the people they put together at the CPE committee and the Model Rules Task Force are premier folks, and it was diverse, and the input that went into the discussions, tremendous. So my hats off to them because they did a terrific job. So what we do was, back in November, once we identified the projects that might come along, I, at least from my side, identified from our committee who would have an interest in certain volunteer activities. And so we established 4 task forces at that time. Some of them have been hurry up and wait, because we're still waiting on the underlying work. Not because they're slow, it's just because we wanted to have the people in place, and Ted Loden and his folks were kind enough to allow us to kind of sit in and listen to some of their dialogue that they've had, so that, and Andy DeBoff chairs that particular task force, so they'll be ready to look at the language that might be necessary if the International Pathway project goes forward. Noel, do you have anything to say about that?
On this one in particular, there's going to be a balancing of a lot of factors. We're looking at something that's different from the traditional reciprocity approach and more of a unilateral one, and recognizing those that could come in purely own qualification without regard to whether or not their country grants it. There are going to be some constitutional considerations to take into account to make sure we get it right and it works. Also, be cognizant of any treaty obligations that we have and make sure that it works under those as well.
Thank you. Something that was not on our original agenda really came with the passage of SARS 21 or immediately thereafter. And we had a working group phone call. I wouldn't even call it a task force, a working group phone call that was very productive in identifying that there might be language in the UAA that either needs to be modified or corrected. Now, at this point, there has been no definition of if any of this needs to be done either substantively or non-substantively. We're just, at this point, we're going to be providing, NASBA is going to be providing at least a memorandum that's going to review the particular sections of the law and the rules and see if there is something we need to do. We really can't move forward on that because we're still waiting on what's going to happen with the ARSC and how compilations of prospective financial information may go forward. So we don't want to rush into this quickly. We just want to let you know that we have some questions, and that will all be worked out over the next several months.
Coalter, I'd just add a couple of thoughts there. I think the idea is that the UAA committee would be looking at, try to make sure that the full intent of the standards change, that's captured, and that our statute, the Model Act and rules are consistent with that intent, and make sure that our definitions still work, you have to be very careful when you do define a new type of service, which is what has occurred in SARS 21. With regard to the sort of pending uncertain change with regard to compilation of prospective financial information, that's potentially is a situation where a group of services or a type of service would be moved out of one set of standards and into another set of standards. Since the definition of a test is tied to specified standards, SARS or SSAE, SAS type of standards, then if you move it from one to the other, you might be not only changing the definition of a test, changing what has to be peer reviewed or offered through a CPA firm. So we just want to be careful that we look at that, make sure that the UAA and the standards are in sync. So it's more at this point questions than it is answers.
Thank you. The bulk of what I'm going to speak about today is a never-ending, seems to be a never-ending project or question. A year and a half ago, 2 years ago, Barton Baldwin, Lori Drews, and other people who don't feel danger is a problem for them, and folks from the AICPA undertook the charge to determine whether the current language in the UAA for determining when someone's inactive was appropriate. So why is that important? The obvious thing is, y'all are all getting older. And as such, we're going to have a lot of folks, even a couple of my Texas board over here who are retired and want to, maybe kick back and take it easy. As it says here, we all know the demographics say is that most of the profession's in its 50s and may reach its 60s. Now, the history behind this was back in '97, the AICPA Council passed the model rules 6.6, 6.7, and the Act itself 6D, which I'm going to show you in a second. And that became the initial language in determining. Now, here's what's really happened. Since that time, that language it says inactive. It doesn't really have retired. But states have decided to kind of go their own way. And Noel, if you wouldn't mind, if you would kind of let us know some of the ways they've done it.
Sure. At its essence, it's just a definition of how you can be exempt from CPE. It's not an exemption from licensure, or at least that was not the intent. The states have really scattered in a lot of directions. Looking at the UAA as a whole, there is, and some of this is judgmental, but there's, it's a substantive, if not compliance, I would say, working together, closeness among the states with the 2/3 of the important parts of the UAA. But on one place where there's more difference, it's in the area of how they handle the exemption to CPE. We have about half the states that use both inactive and retired. One or two states that actually also use the term of emeritus as well. And then about a third of the states, really a little bit more than that, also turn on age, use an age criteria. And even within those states, it ranges from 55 to 60 to 65. So there's a lot of variation among there. And then what constitutes being inactive that is not engaged in professional services is also something that many of the states have struggled with, and there are lots of different examples of how states have been able to interpret this. And none of that's to say that any of the states are wrong, because they have other aspects of their laws or principles that they want to follow, but nevertheless, to the degree we can, and to the extent that mobility can be impaired by significant differences in CPE requirements, and we want to strive for a clearer message and some more consistency. This occasionally comes up in court battles, and there was one in South Carolina that was actually requested the U.S. Supreme Court to review it. The review was denied, but basically an inactive CPA from another state had come into the state and was teaching at a university there. And the question was whether or not they had to get a license in South Carolina. So these things can come to the fore, can give rise to court case challenges as well. So the idea is to strive for some consistent line.
It may not seem important that we have these differences between the states. If it's not broken, don't fix it. But at the very bottom of the slide, there is a question, and that's what is the impact on mobility? If you're inactive in one state under a set of rules, move to another state, what do you have to do? If you're retired in a state, Rocky Duckworth over there, if he wants to be CPA retired and then moves back to Oklahoma, I don't know why, but just say he does, then it may be different for him. So we'll continue to explore that, and we have the folks in place to do that. Now here, I had skipped ahead to the slide here. This is the current language in the UAA, and this is not language that really has anything to do with licensure. What this language is about is exempting you from CPE. So, no or reduce CPE, the possibility of getting your fees reduced. There's a question is, how legitimate is that? I can't answer that. I mean, there are legitimate reasons, clearly, for someone to become inactive retired. They may be health-related, disability. In Texas, we actually have a disability standard that we use. If they're in the military and they're overseas, that's another reason. And there's other good causes. I know Arkansas has a good cause that they can allow for the exemption. And so at least in their case, they'll look at individual circumstances and facts to determine what they want to do. I mentioned the prior task force. I think Steve McConnell's here. He was the chair of that task force from the AICPA. And I said Barton Baldwin was as well. And they were asked to take a set of questions. And they were facts and circumstances questions, and ask and answer, could in these situations, under the current language that I just showed you, could that individual provide those services? And they went through a very healthy list of, I think it was 15 or 16, Barton. And I'll give them a lot of credit because they could have shied away and taken the easy way out. But in virtually all the circumstances that they had, for example, the one I've got on the screen, if you are providing services, volunteer services, to prepare tax returns under the VITA program, this language doesn't allow you to do that. These services you can't provide on this language don't have anything to do with compensation or no compensation. So my hat's really off to those folks because they answered the hard questions in the way that a lot of people didn't want to see, but they did it. The leadership of the AICPA and NASBA then asked us to kind of take another look at this and see whether there is something that we can do with it. Now, that in mind, with 55 jurisdictions and probably 54 ways of doing it, is there a way for a newly comprised task force to take this language, adjust it either in the act or the rules, and move forward with something better, but at the same time protecting the public interest? So so we had the new task force formed. I asked Barton to chair it again with his familiarity. Lori Drews, where are you? Lori Drews, I pick on her too. Don Rulian from Alaska was on it as well. He's not here for this regional. We'll be at the annual meeting though. And they've spent some time on this. And both Lori and Barton with the original task force and the new task force. And there's been some spirited discussion with both our folks and the AICPA folks on this. But they're working together, and I'm real happy that we're doing that. So what comes out of this, at the very bottom of this slide, begins it. what they were charged with, and I've asked us to do as well, is to look at these questions and vet them, and they have. Number one is, do we need both statuses, inactive and retired, or is that confusing? Can we just tweak the language of the Act, or do the model rules, can they help play a part in fixing this? Because the bottom line at the end of the day is, if we put something out there that we suggest new language and nobody adopts it, yeah, it's great, it's uniform language, but what have we done? So that was charge number one. What scope of allowable activities would be CPE exempted? Can you serve as the treasurer of the PTA? Or just be a PTA member? At what minimum age can you ask exempt status? Do we want a CPA who just got their license a year ago to become CPA inactive? Do you need to be in good standing, either for a period of time, 20 years, 30 years, 15? Or is it something that, as long as you're in good standing right now, you can apply for and you'll meet that criteria? And this is another one that's been interesting in trying to match this public protection, yet maybe not having to do quite as much work. And that is, instead of having no CPE, maybe having a reduced level of CPE if you're providing those, like I said, the services for the VITA program, or you're serving on a nonprofit board. And the question is what is the assumption of people that you're serving with on nonprofit boards? If you have the term CPA inactive or CPA retired, do they still consider you a CPA fully invested in your educational outcomes and learning and keeping up with things? I don't know. I can't answer that question.
Coalter, I think you're hitting at the heart of the matter in terms of public protection. The fundamental question is going to be, will it be necessary to public protection that CPAs who are only doing limited things or volunteer things or serving on a board of directors for a nonprofit, is it in public protection interest that they still have 40 hours a year of CPE? And I asked that, but I imagine what a judge would ask me if we're ever challenged with regard to a requirement like that. Other professions have moved in different directions. Attorneys do have required continuing education. They have an exemption if you have been in practice for a number of years, have a clean record. You're still subject to the bar's jurisdiction. You still have a professional obligation, even if you're doing things as a volunteer. If keeping up and continuing education is implicit in that, then they expect you to do it, even if it's not required by the rules. Architects also have that. They call it architect emeritus, but have a provision for architects at a certain point after a number of years of practice to be able to move in that category. And they look at that a little differently from the inactive category, which is someone who, for a variety of reasons, may need to step out of the practice, either for medical reasons, disability reasons, maternity reasons, or whatever job requirement, or working overseas, for example. And so other professions also have models for that may offer some guidance for us.
Okay. One of the things that you're charged with doing here, especially in the breakout sessions, is to interact with your colleagues from other states. I'm going to also ask you to do me a favor, and if you have specific ideas of what you think would work, but your state might be willing to adopt or change, we'd love to hear it. I've already got Lori to raise her hand. So, and the other target over here is Barton Baldwin. If you'd raise your hand, Barton. Myself, Gary McIntosh, if you'd raise your hand as well. He's the chair. I don't believe Nancy's here. If she is, no. But grab a hold of us. Give us your thoughts on what you think would work. Once again, 2 important points: public protection, mobility. That's number 1. So where we are now, the Joint Task Force has coming close to formalizing their recommendations, and they're going to be putting that together for the full UAA task force over the next, hopefully, month or two, especially after we get some feedback from you folks. Then they'll provide some model rules requiring CPAs who request any exemption under any situation we do to have a written affirmation that they understand the limitations on what they are able to do professionally if they are granted, whether it be CPN active or any other title. And I think that's an important provision that we get them to, in writing, give us that affirmation. From there, it will go to the AICPA Council. Once it gets past the UAA committee, it goes to the NASBA and AICPA Board of Directors and for further vetting, and the AICPA Council, which I believe they meet in October again. So we'd like to have a fairly short time frame on this to get to a point where we can expose it. So if it once it gets to the AICPA Council and it's approved, at that point, then it could be exposed to the state boards for their comments. And from there, depending on what we come up with, hopefully we can get something that many states can tweak what they have and to allow it to fit within that model. So the UAA committee is where the rubber meets the road. We really tackle anything and everything that's thrown at us by committees and leadership. And we haven't met yet, but Gary and I will be meeting, I guess, in the near future, talk about possible future projects. Like I said, we haven't talked about them, so I don't expect him to know what I put down here. But clearly the education issue with Bob Cochran's committee and with Carlos Johnson and the accreditation area, that's one. Always important, any changes to the CPA examination. Peer review changes. I know we're going to have a presentation from Jim Brackens and I think Janice Gray on what's going on there. And then, of course, any other issues that you state boards identify for NASBA that could benefit the profession and to allow us to continue the movement toward mobility. With that, I would entertain any questions. Okay. Well, like I said, if you have questions, ask Barton, ask Lori, ask Gary, and I'm available as well, but I prefer you talk to them because they are the boots on the ground on this, and I'd probably get in their way, and Barton knows I would get in his way. So that concludes our presentation, unless Noel has anything else to say.
Nope.
Okay. Thank you.